All right, good evening, everybody. Looks like we still have some people who are signing in right now. So really quickly, we are utilizing closed captioning this evening. I know some of you have heard me say it before, but if you'd like to turn off the closed captioning system, at the bottom of your screen, you're going to find the closed captioning system labeled as live transcript. And from there, you can go ahead and hit the hide click the hide subtitles button, or you can click on the subtitle settings to go ahead and adjust those subtitles so you can make the text bigger or smaller. I want to thank everybody so much for joining us this evening for another Date with History presented by the First Division Museum at Cantini Park and the Robert R. McCormick Foundation. We're so excited you were able to join us this evening as we dive a little deeper into the Nuremberg trials this evening. Now, for those of you who are not familiar or did not know this year marks the 75th anniversary of the Nuremberg trials. So we're very excited to learn a little bit more about it this evening. But before we dive into that, I just want to do some quick reminders on what's upcoming here at the First Division Museum. So first things first, I always like to remind everybody when our next Date with History presentation is going to be. And our next virtual Date with History will be on Thursday, June 3rd at 7 p.m. Central Time, right here on Zoom. And we're going to be discussing with Dr. William C. Meadows, and he's going to be talking about his new book, The First Code Talkers, Native American Communicators in World War I. Really excited to dig deeper into this topic, and you can go ahead and sign up for this one online at fdmuseum.org. And again, this is a free presentation. Now, something brand new to tell everybody about, since we are learning more about the Nuremberg trials this evening, I want to let everybody know that in the lobby of the First Division Museum, starting next week on Wednesday, May 12th, and running through August 1st, we're going to have a new lobby display to commemorate the 75th anniversary of the Nuremberg trials. And the display is titled Nuremberg, Nazi Germany on Trial. Now, the exhibit or the display is free to see with entry. So I want to remind everybody that right now the First Division Museum is on a ticketing reserve system. So make sure you head over to fdmuseum.org underneath the events section on our website, and you can go ahead and reserve your free tickets there. Make sure you check before you come in. There is very limited walk-on space currently, so make sure you check online first and see if you can reserve your spots. Now I want to go ahead and start getting our introductions done. So I'm gonna take my screen down. I wanna remind everybody this evening that in the last 15 minutes, we will be doing Q&A, our question and answer section with our speaker. And to submit questions to us, you're gonna go onto the bottom of your screen and you're gonna find the Q&A button with the two little talk bubbles on it. And you can send us your questions via there. We'll be getting to those in the last 15 minutes. And I will get to as many of those questions as possible. We always have a lot of them. I want to make sure we get to as many as possible this evening. I also want to say a special welcome to our Illinois State teachers who are joining us this evening. If you have any questions, they're here for their teacher professional development credits. Feel free to send me an email and I am happy to help. Now, I do want to introduce our speaker this evening. So everybody join me in welcoming John Geiringer. So let's say hi to John, everybody. Welcome. So John is a partner at the Barack Ferrazzano law firm, and he's also a co-director for the Consortium for the Research and Study of Holocaust Law at Chicago Kent College of Law's Center for National Security and Human Rights Law. So welcome, John.
Thank you. Thank you so much for having me today. It's such an honor, I have to tell you.
We're so pleased to have you. So John's going to go ahead and pull up his presentation now, and I'm going to send it over to him. Again, please feel free to place your questions down in the Q&A bubble at the bottom, and we'll get to them at the end of the presentation. Take it away, John.
Great. Thank you, Laura. And thank you all so very much. I know everybody has Zoom fatigue, so I'm really privileged to be here. And I have to say, for me, this is really an intergenerational event because you know, when I think about the U.S. Army, I have to think about my dad, who was liberated by the U.S. Army in Verviers, Belgium. And so then we move across the generations and I think about my kids, and I've got very, very fond memories of visiting the museum and its surrounding area and all the tanks and be able to play with them when they were young children. So I have very fond memories of that as well. So for me, this is truly a distinct pleasure and honor. We have a lot to cover tonight, very ambitious agenda. 4 hours, right? I think? No, just kidding. We're going to try to squeeze this all into an hour and 15 or so. Happy to take any questions. And if we run out of time, please feel free to reach out after this. As Laura mentioned, my daytime job is I'm a banking lawyer, but at night I help run the Center for National Security Law at Chicago-Kent College of Law. And within that, we have something called the Consortium for the Research and Study of Holocaust and the Law, what we call Crucial. And we think it is a crucial mission, and we encourage all of you to visit our website. It has plenty of fantastic materials about not just the Nuremberg trials, but every legal aspect of the Holocaust. And that can be First Amendment issues, restitution, restoration, and a few of us are getting together and actually writing what we believe is the first comprehensive treatise on Holocaust and the law. So stay tuned for that. But in the meantime, let's dive in, shall we? First, a little bit of background. And I thought it might make sense, since we are talking about the Nuremberg trial, the first one, and we'll see that there were some subsequent ones, as well as the laws of armed conflict. So I think we should go a little bit back through time to talk about how some people may view the laws of war, right? Cicero may have said, inter arma einem silent legis. That's my Latin for the day. There'll be more. Basically, when war comes in, the law becomes silent. What Shakespeare may call all's fair in love and war, and what Clausewitz might say, Kriegsraison geht wie Kriegsmanier. Basically, the reason for war goes before the sort of the laws, the manner in which war is conducted. So this is how I think people typically understand the laws of war. And what I'm going to show you today is that's not quite accurate, and even wasn't at the time of World War II. More Latin, so I can only imagine how the closed captioning is picking this up. Jus ad bellum is the legal principle around how parties engage into armed conflict in the initial stages. So basically how countries get into war. Jus in bello is the phrase that's used once you're in the war. What are the laws and regulations surrounding what you may do in war? And jus post bellum is regulating the end of warfare and return to peace, what we've seen in Iraq, what we've seen in Afghanistan. And so if we go back to early Christian times, we think about St. Augustine and Thomas Aquinas and the like, we think about this concept of just war, that it has to be a just cause to get into it, must be used only as a last resort, declared by a proper authority, namely a government, possessing the right intention. You've got to have a reasonable chance for success, and the ends are proportional to the means. And we'll see that these threads from early Christian thought are really imbued in some of the various strategies and the regulations that we see surrounding war today. And if we go back, you may have heard of the Kellogg-Briand Pact, which is something that for a long time had a lot of notoriety. Generally was called the General Treaty for the Renunciation of War as an instrument of national policy. There is a Chicago connection to this. Basically, after World War I and the devastation of entire generations in Europe, Chicago private sector lawyer, that's why I'm kind of proud to have another Chicago private sector lawyer with a funny name, Salmon Levinson, saw the carnage there and really started this peace movement that eventually blossomed into the Kellogg-Briand Pact. They're the ones who happen to get the credit, but really some of it goes to Salmon Levinson for starting it. And it really, what it was a treaty, and Germany was a signatory to this treaty, prohibiting aggressive war. Now, what you'll notice that it didn't have an enforcement mechanism. It didn't say if you engage in aggressive war, something bad will happen to you. There's a penalty, there's a fine, there's crime. It doesn't say that at all, but it was, at least in theory, and it's still on the books today, believe it or not, that this international treaty that moved us away from how war used to be conducted, in that basically you'd settle grievances, into the last resort, just like we saw under just war theory. It's gotten some recent rehabilitation. You may have seen a book called The Internationalists by some Yale Law faculty who said basically, this was a paradigm shift in the way that the world looked at war to engage in international relations. And jus in bello Same thing. Remember, these were the laws governing once you're in war. We see back through antiquity, the ancient Jewish texts in the Torah and in the commentary around the Torah and the Talmud. There are rules surrounding warfare. We see that in early Muslim beliefs, in Hindu beliefs. And then we fast forward a bit to the Battle of Solferino in 1859. And what that was the French and the Italians versus the Austrians. And basically, it was really on the road to leading to Italian independence. And there was a Swiss businessman named Henri Dunant, otherwise known as Henri Dunant, proper French, right? So Henri Dunant witnessed this Battle of Solferino and the aftermath, the agony, the hundreds and thousands of bodies and sick and injured just laying around. And it impacted him so much that you can see where this is going, Swiss, right? He was the one who created the International Committee of the Red Cross. And the RCRC is really the governing body for some of the various laws of war on the international level that we see today. We also have in the United States, the Lieber Code, General Order 100. Lieber was a legal, basically theoretician that Abraham Lincoln tasked with developing rules of law here in America in the Civil War. And the Lieber Code was the genesis of many of the LOAC, the laws of armed conflict principles that we see today that we're going to talk about in the second part of this presentation. The Geneva Conventions, if you look at the beginning, you see 1864, 1906, and 1929. What's clear there is we had Geneva Conventions before World War II. So it was not the case that all was fair in love and war. There were certainly rules regarding warfare. And then obviously the one in 1949 basically corrected the wrongs that the Nazis did. And then the Hague Conventions. The Hague Conventions were a separate body of law that basically spoke about what kinds of weapons you can use in warfare. Okay, so really two different traditions in use in bello. So let's go back to World War I. World War I in Leipzig, a town in Germany, there were actually war crimes trials. Basically, what needs to happen under international law is, to the extent possible, we want each country to try their own war criminals. And that's what we allowed through the Treaty of Versailles, to allow Germany to do for themselves through their Reichsgericht, their Supreme Court. And if you think about it, there were, in the entire battles of World War I, Germany only identified 900 potential war criminals that they whittled down to 45 cases, that they whittled down to 12 defendants, and then they whittled that down to only 6 convictions of war crimes. And then even then, some of those inmates somehow magically were let free or escaped or had lenient sentences. So it left a really bad taste in the mouth of the Allies, having seen how the Germans took care of their own, so to speak, in connection with war crimes of the previous war. So let's move on to World War II. As the Allies were becoming aware of German atrocities, what they wanted to do is signal not just to Germany, but to its allies that we have you in our sights and you will be brought to justice. And so here you see a series of condemnations and warnings and planning for what ultimately became the Nuremberg process. We had the St. James Declaration in 42, and then later the Moscow Declaration, the Tehran Conference, and the Yalta Conference. At each step of the way, we became closer and closer and closer to developing the tools and the techniques and the architecture around what became the Nuremberg trials. It also was a way to signal maybe not Germany itself, but certainly its allies. And we see as the tide of the war turned in World War II, we saw certain of its allies basically stop doing some of the atrocities that they were doing in the beginning of the war, likely because they didn't want to be on the crosshairs of the Allies after the war. Now, even in the United States, there were different questions around what we should do, because in those conferences we saw before, we had Churchill and Stalin and Roosevelt kind of jockeying over what it should look like. You know, Stalin at one point says, let's just shoot 50,000 of the top criminals. And they went back and forth, and Roosevelt joked, well, what about just 49,000? Ultimately, what wound up happening is in the United States, you had two schools of thought. you had Henry Morgenthau, who's the Secretary of Treasury, Jewish, really wanted to throw Germany back into the Stone Age. Forced deindustrialization, partition, make them all agrarian, and the execution of arch criminals. So you had Morgenthau on one side. Then you had Henry Stimson, the Secretary of War, and he had a colonel named Bernays, Murray Bernays, who basically said, no, let's use this as not a show trial, but as an education trial. And so they decided, let's do this trial of European war criminals. And that's ultimately Stimson won over Roosevelt more so than Morgenthau's plan. Now, there were trials even before Nuremberg. So you may have heard of a famous case called Ex parte Quirin, which is a Supreme Court case that actually is used to this day in connection with how we're supposed to treat the Guantanamo prisoners. It was a famous case involving really a bunch of Keystone cops, 8 German saboteurs in the US. They were deemed to be unlawful combatants. 6 were executed, 2 received prison and then deported in a very, very fast trial. There were US Army trials as well, as you can imagine, as the US Army came in and liberated the camps within its jurisdiction. You know, obviously the Soviets were liberating places like Auschwitz, but we were liberating places in Germany, Buchenwald, Dachau, etc. And they conducted trials, the Army did, basically at those sites, 460 trials, 1,600 defendants. There were even, as you're probably aware, instances where they just basically let prisoners beat up and kill their SS guards, or the US troops basically shot them up themselves and not even having given them a trial. But there were certainly elements of justice before the Nuremberg trial that had taken place. And so now we get to the Nuremberg trial. And there's, I think, to this day, some confusion when I say Nuremberg trial. There was one trial at the beginning, and that was called the International Military Tribunal. And that's the one that is the most famous one. That went from 45 to 46. And we'll see in a second, there were another set of trials, another 12 trials called well, we'll get into it in a second before we get ahead of ourselves. So as you can imagine, any trial system that is created from scratch really needs to have an organizational document, and that was called the London Charter. So the London Charter had a constitution, it had jurisdiction and principles. They talked about investigation and prosecution, how to conduct a fair trial. For those of you lawyers in the audience, the rules of evidence were very much relaxed. So here, as many of you are aware, if you have trials in the United States, you have to be careful about things like hearsay and other evidentiary guardrails that we put in place. In the London Charter, basically, they allowed just about everything in so long as it was probative. So as long as it was germane to the topic, it was let in, even if we would call it hearsay in the current trials. In one of those subsequent Nuremberg military tribunals, there was a case where Judge Musmano, this was the Eisansgruppen case, which is a fascinating case in and of itself. We can talk about that if we have time. Basically had what he called the penguin rule, meaning he would let anything, any kind of evidence in, even about the love life of a penguin, if it was germane to the topic. And in fact, the defendants gave him a little penguin at the end of the trial as a show of respect. So you get the idea that we wanted to let in and really show to the world that we are giving these Nazi defendants, a fair trial. We're letting in evidence, and they're
John, it seems like our audio has stopped for a second, so let's give you a second. All right, let's test the audio again, John.
Can you hear me now?
I can hear you now. Looks like it just dropped out. Modern technology, everybody, it happens. All right, John, if you could just back up just a hair.
Okay, so if I'm backing up a hair, this London Charter was established to put together the architecture around the court system and allowed evidence that normally we wouldn't let in these days in terms of hearsay in the US court system. We wanted to really convey to the world and to the German people that we wanted to have a fair trial for these defendants. And so there were 4 indictments that were issued. The first one was known as Crimes Against Peace. And remember, if we go back and we talk about that Kellogg-Briand Pact, right? That's the one that restricted aggressive war. And so the first count dealing with crimes against peace talked about planning, preparation, initiation, waging of a war of aggression. No surprise here, right? We know that Germany invaded a whole slew of countries. What I think is most interesting is that when they invaded Poland, so the first, they're obviously in the Sudetenland and the Rhineland and other places before, but when they came to invade another country as a whole, when they invaded Poland, they created what we would today call a false flag operation. So they took some concentration guard inmates, dressed them up as Polish army soldiers, shot them full of holes near a radio station, and actually pretended like the Germans were the ones who were being attacked by the Poles, and all the Germans were doing is engaging in self-defense. So it's clear that even the Germans knew that waging aggressive war was against, certainly at the very least, international norms. And so that's why it's kind of interesting for them to defend themselves against waging aggressive war when even they themselves in the invasion of Poland pretended like it was in self-defense. The next indictment was what you'd expect, war crimes. Basically, the whole slew of maltreatment, ill treatment that they did the prisoners of war, killing of hostages, destruction of cities, not justified by military necessity. And we'll see in a second how important this notion of military necessity is to this day when we're talking about the laws of armed conflict. And so some examples of those war crimes incidents, if there was no Holocaust, I think what the Germans would be most damned in history for would be their ill treatment of Soviet POWs. They captured 5.7 million, and 3.3 million of those died. And they usually died slowly by starvation, exposure to the elements, etc. And so we'll see in a second, if we have time to talk about some of the other trials, that a lot flows out of this mistreatment that they did for Soviet soldiers. There was the Commissar Order, which was an order given to the military that to the extent that they find one of these commissars, which were basically Soviet political officers, they were to be speared away and taken care of right there on the spot. There was something called the Nacht- und Nebel-Erlass, which was the night and fog decree, which is same thing, except not for commissars. For others, basically speared them away, give them a quick show trial, if that, and kill them. There was the Commando Order, which basically said to the extent that the German military captures special forces belonging to the Allies, those special forces were to be killed immediately. And then many of you, especially if you know your American World War II history, are probably familiar with the Malmedy massacre in Belgium near the Battle of the Bulge, where there were 84 US POWs who were taken prisoner and basically just shot up in a field. And so these were some of the many, many, many examples of war crimes that they were accused of. The third one, the third indictment, was called Crimes Against Humanity. And think of this as the crimes in which they engaged to civilians. This was the Holocaust. This was the concentration camps. This was whatever they did, however they perpetrated against civilians, as opposed to the last count, which was primarily against fellow soldiers. And we all know what these crimes against humanity are. Even before the concentration camps, you had something called Einsatzgruppen, basically mobile task forces, mobile killing units, who either went to a village and shot up all the Jews and all of the commissars and others that they deemed to be threats, or as their thinking evolved on how to kill more efficiently, they used gas vans. They finally in Chelmno made those gas vans stationary, and that's eventually what led to the gas chambers that we know of today that are so iconic in Auschwitz. You know, we know the major killing camps, what are so-called the Operation Reinhardt camps of Belzec, Sobibor, Treblinka, where it was basically a killing camp and nothing more. But there were other camps. Auschwitz was a bit of a blend between slave labor camp and extermination camp. But researchers have documented over 40,000 camps that were run by the Nazis in World War II. And then the last count was really an American invention, a common plan or conspiracy, basically borrowed from what we would today call RICO laws, basically weaving together every element of German government and even broader society to say that nobody did this alone. All of you were part of the same pact, all of the same common plan. And some of the more famous examples of this, this is a famous letter from Hermann Goering, who was basically the #2 in the German government, to a guy named Reinhard Heydrich, who is a famous guy. You may have seen the movie Conspiracy about the Wannsee Conference. He was in charge of basically a German security organization called, here's a big German word, called the Reichssicherheitsamtamt. Wait till you see it spelled out in the next slide. It's basically the Reich Main Security Office that weaves together some of the organizations you're probably very well familiar with, the Gestapo, the SS, and the like. So this was a letter from Goering to Heydrich, although historians believe that Heydrich actually drafted it, basically saying Goering will direct Heydrich to do what we would today call a feasibility study. We want to kill a lot of Jews. You figure out how to do it. And of course, they use very euphemistic language here, but this is, if you're familiar with the term final solution, this is where the final solution comes from. So you see what I underlined. First, he talks about a total solution to the Jewish question. And then later at the end, he talks about, please give me this plan for this final solution to the Jewish question. And if you think about it, those Einsatzgruppen units who were in Russia in the summer were shooting up Jews and others. And the problem with it was psychologically damaging, not to the victims, but to the shooters. And that's one of the reasons why Goering and Heydrich and others wanted to create a more efficient, effective way of killing mass amounts of people in a very short time, which ultimately, of course, led to the concentration and the extermination camps. This is that Wannsee conference I mentioned. So what you see, and here you see Reichssicherheitsamtamt fully spelled out. There won't be a quiz later, so don't worry. You've got different elements of society. So we start with 4B4, Adolf Eichmann. The famous Eichmann was really Reinhard Heydrich's #2. He was in charge of Jewish affairs. You have the Rusha, the Race and Settlement Office. They would find Aryan kids and basically steal them and take them back to Germany and try to, Aryanize basically Eastern Europe. You had the Gestapo, the Geheime Staatspolizei, the secret state police, and the general government, which was the occupation government in Poland. But it wasn't just the RSHA that was part of this conference. If you see here, you've got what we would today call basically a deputies cabinet meeting. So it wouldn't be like the Secretary of State or the Attorney General, but all of their #2s were part of this. So we see Roland Freisler from the Ministry of Justice. He's famous for being always the judge that's yelling. When you see movies about a Nazi judge who's yelling really loud, that's Roland Freisler. You've got other elements of German society, and what the prosecutors are trying to show here is the Interior Ministry, the Foreign Ministry, the Justice Ministry, all of you were together to make this happen. So let's talk about why Nuremberg, Nuremberg was chosen as a location. Well, I think there were some practical reasons and symbolic reasons. The practical reasons is most of Germany was basically, shelled out. Nuremberg as well. There was one remaining large and undamaged Palace of Justice with an effective prison complex. And of course, Courtroom 600, you may be familiar with that because there's a local Chicago organization called Courtroom 600 that I highly recommend you go to their website because they have all sorts of wonderful pictures and artifacts from Courtroom 600 itself. So strong recommendation to go visit them if you're interested in this topic. There were 24 seats for the defendants, and this is important for this trial and later, because if you look at even the later NMT trials, you'll see they never had more than 24 defendants. Why? That's all the room they had for them in the courtroom. It's not that there were 24 of the worst always. It's just that that's how many could fit in the courtroom. The symbolic reason is, of course, Nuremberg was a ceremonial birthplace of the Nazi Party. It's where you had those propaganda rallies with those lights that extend out to the sky. It's where the Reichstag session, where they enacted the Nuremberg laws, which divided up Jews and Mischlinge and normal Germans in various buckets to decide what to be done with them. So both from a practical perspective and a symbolic perspective, Nuremberg became the place. Now, there were certain people who were not there for obvious reasons, right? Adolf Hitler committed suicide. Heinrich Himmler, who was in charge of the SS, committed suicide. Reinhard Heydrich, who I mentioned before, who was in charge of the RSHA, he was actually, shortly after the Wannsee Conference, was assassinated by Czech partisans later on that spring. And so he wasn't there. Joseph Goebbels, the propaganda minister, he had committed suicide in the bunker. Adolf Eichmann, and if you bring me back, we can talk about the Eichmann trial someday, he went through what's known as the rat line to South America. So he was not there at the time. And there were others who either they were killed in the war, committed suicide, or went through some of these rat lines and couldn't be found yet. Not only did they want to go after certain defendants, they wanted to go after certain organizations. So among the organizations that were prosecuted in connection with the IMT were the Gestapo, and that's the Geheime Staatspolizei, that's the secret state police, the General Staff and High Command, the Leadership Corps of the Nazi Party. And remember, Nazi Germany had a very fluid and very dynamic, you had a state, but you also had a party, and sometimes they would be interwoven and basically become one and the same. You had the Reich Cabinet, you had the Schutzstaffel, the SS, what was originally the Praetorian Guard for Adolf Hitler, that really became the killing machine that it did outside of Germany in the concentration camps. Within the SS, you had something called the Sicherheitsdienst, the SD, which was the intelligence arm of the SS. And then the Sturmabteilung, which is the brown shirts, the storm battalions, many of whom were basically killed in 1934 in the famous Night of the Long Knives. But nonetheless, it was included among the criminal organizations, at least in the original prosecution. The thinking was, what we're going to do is we're going to prosecute these organizations, and then if successfully found guilty, then so long as you were a member of one of those organizations, that was a crime in and of itself. So it was an easy way to try to capture, they had envisioned many trials down the road, which never happened because of the Cold War, but they were envisioning many trials down the road, so long as they could prove that you were a member of one of these groups, you could be prosecuted. Didn't wind up happening for reasons we'll try to get into if we have time. And so these are the defendants, the next few slides, and we obviously don't have time to take a deep dive in each of them. What I strongly recommend, and I say this a little cheekily, is adopt a Nazi. Find a Nazi that somehow resonates with you. Because as I mentioned before, we have various elements of the Nazi regime. We have folks from the army, the Navy, justice, propaganda. So if you're into media, maybe take a look to see what Fritzsche did. If you are into banking like I am, maybe see Walter Funk, see how his life story and the decisions he made along the way got him to where he was. Because the sad thing, the more you study this field, is Nazis are not these alien zombies that came to Earth and then left and you'll never see them again. I think, when we did an event at our center last year, we called it Holocaust and the Law Lessons for Today for a reason. We obviously see elements of this bubbling back into society. And what I encourage you to do is find one of these folks, dig into their background and see what resonates with them, why they made the decisions they made, And maybe, you know, we don't want to lump them all the same, because as we'll see in a second, each one of them got slightly different sentences, depending on whatever malfeasance that the judges believe they had. And so, as I said, we can go down the list. We've got folks from the army, from the government here, the deputy for Rudolf Hess, who famously, don't forget, he was the one who spirited away in an airplane in 1941 and was basically a prisoner of the British for the whole war. And yet he was thrown in the mix here because he was basically Hitler's right-hand man for a while. He helped him write Mein Kampf. And so, you know, laid the seeds for what was to come afterwards. There was even one non-government official here, a fantastic German name, Gustav Krupp von Bohlen und Halbach. He was involved in the Krupp company, which was played a monstrous role in the Holocaust. And actually, by the end, he was actually released because he was too ill to serve. There was actually confusion among the prosecutors whether or not to prosecute him or his son. And eventually, it didn't work out. The dad was too sick. But later, his son was brought to trial in a subsequent NMT trial, right, Nuremberg Military Tribunal trial involving the industrialists. So we can see if we can get to that later. We have the German Labor Front, the Foreign Ministry, the Ministry of the Eastern Occupied Territories. And again, we'll share this PowerPoint with you so you can certainly use it to conduct your own research. Julius Streicher is a very interesting one of the defendants because, he was basically a propagandist, of kind of the worst kind of Nazi propaganda, Der Stürmer, which was a combination of anti-Semitism and nudity. And it was just a grotesque kind of document. But, it's an interesting question, and we're facing this today, I think, as we're seeing in connection with the January 6th attack on the Congress, is that, to what extent does incitement, does propaganda play a role? And should Julius Streicher, even though he was one of the most loathsome of all the people here, the question is, does simply authoring a pamphlet that inspires others to do that, should that be enough? That's a fascinating question for another time. And so what I encourage you to do is watch Robert Jackson. He was a Supreme Court justice who was on leave, who became the chief prosecutor for the United States. And what's interesting about it is that it was all translated in real time. So he had to speak very slowly and it was translated in real time into 4 languages. So it sounds a little stilted, but it's still extremely powerful that, when he says the wrongs that we seek to condemn have been so calculated, so malignant, so devastating that civilization can't tolerate them being ignored because it can't survive their being repeated. When you get a chance, very worthwhile to watch his opening statement. His cross-examination wasn't so good. And there's been all sorts of media portrayals of him against Goering and how his cross-examination really didn't meet the test of the time. But his opening statement and his closing statement were truly profound. The defenses of the defendants were what you would imagine. This is just Victor's judgment. You are prosecuting us ex post facto for laws that didn't exist at the time. Or as they would say in German, Befehl is Befehl, an order is an order. We're just following orders, the famous Nazi defense. And again, a little bit more Latin, tu quoque, which is basically you did the same thing. Now, what's interesting is that the tu quoque argument was prohibited by that London Charter, and yet it was used by one of the admirals in the trial to basically, from Admiral Dönitz, who actually was briefly president of Nazi Germany after Hitler committed suicide. He used a document from Admiral Nimitz, who was in charge of the Pacific Fleet for the United States, saying, we did some of the same things, not exactly the same, but we did some of the same thing with respect to submarine warfare. And that actually is thought to have brought down his sentence, as we'll see in a second. And here we are, the sentences. So as you see, it's not as if everybody was sent to hang. Most of them were, and you see the list, and it's probably the ones you'd expect. Although Goering, who was the lead defendant, was able to cheat the hangman's noose by getting a poison tablet snuck in, and he was able to commit suicide. But you'll see at the other end of the spectrum, we have three that were found not guilty. Fritzsche, who was basically the second in command on the propaganda ministry, he was found not guilty. Papen, he's the one who actually kind of brought Hitler to power. I think it's because he was deemed to be too old. And Hjalmar Schacht, who was also a central banker, just like Funk was. But he was actually in a concentration camp at the end of the war because he was accused of being part of the plot that was famously portrayed in the movie Valkyrie. So it's interesting that Schacht was actually deemed to be an enemy of Hitler at the time. They were found not guilty. Even after the war, though, there were some additional criminal sentences on them, although Schacht, basically the rest of his life became a very well-known consultant to third world countries in terms of their debt and other banking needs. And so again, it's fascinating to see. And if we had more time, we could talk about Speer, who was the armaments minister, and how he only got 20 years, whereas Sauckel got death by hanging. Sauckel was in charge of slave labor, and yet Speer used that slave labor and only got 20 years imprisonment. And it probably has a lot to do with, he was one of the few who showed remorse in connection with all of the defendants. Out of all those criminal organizations I told you about before, the only ones who were actually convicted were the Gestapo, the Nazi Party leadership, the SS, and the SD. So basically it allowed for, in those subsequent NMT trials that I mentioned, so long as they could show you on a roster, and the Germans took fantastic notes, as you know, so long as they could show you on a roster of those organizations, that could be a criminal charge. And so these were the Nuremberg military tribunals that I mentioned earlier. There were 12 of them. Unfortunately, what wound up happening is that Cold War politics got in the way. And instead of having folks like Justice Jackson, you know, a Supreme Court justice of the United States, being the lead prosecutor, and Francis Biddle, who was our Attorney General, being our judge for the United States in connection with the trial, basically by the time these trials came along, there wasn't all that much interest. You had, you know, relatively unknown people serving as both prosecutors and judges, with some notable exceptions like Telford Taylor. But if we think about, for example, let's take number 9, which is the famous Einsatzgruppen trial that I mentioned earlier. You know, you had Ben Ferencz, who is still alive at 101. Thank God, he's going strong. But at the time, he was a 27-year-old, fresh out of Harvard Law lawyer who was assigned to something else. And he had looked and found basically 1 million deaths in the Einsatzgruppen reports, and told his boss, Telford Taylor, we've got to try this case. 100 million deaths for these murder squads. And Taylor basically said, look, we don't have a lot of time. We don't have a lot of resources. You do it. And so this 27-year-old punk who had never tried a case before became part of what was known as the greatest murder trial in all history. And the other trial I would just quickly highlight is number 3, the Justice Trial. That's the one that was made famous in the movie Judgment at Nuremberg. And so I think people conflate the IMT and the NMT trials. But if you see the movie Judgment at Nuremberg, that's actually about this third trial here against judges and lawyers who were involved in the Nazi regime. Like I said, if you bring me back someday, we can do a deep dive in one of these. All right, let's take a breath and turn the page, so to speak. That was, in brief, the IMT trial and a little bit on the NMT trials. And as promised, we want to talk about how those influenced today's modern laws of war. Here in the States, we call it LOAC, the Laws of Armed Conflict. Overseas, they're more likely to use the phrase IHL, or International Humanitarian Law. And so let's go through. We only have time really to hit some high-level examples of this. So LOAC, what are the main purposes here? And so the main purposes are protect, and again, this is basically whatever the Nazis did, do the opposite, right? So we have protecting combatants and non-combatants from unnecessary suffering, provide protections for those in enemy hands like POWs, the wounded and the sick and civilians. We want to facilitate a restoration of peace and ensure a disciplined, ethical, and effective use of military force. So even though it's restrictive on us, it ultimately helps humanity as a whole. We want to preserve the professionalism of the combatants. We want to prevent, as much as warfare is itself savage and brutal for anyone who's actually been in it, we want to prevent that as much as possible. And so to do that, there were developed after World War II, the Geneva Conventions, which had, as I said, its roots with Henri Dunant back at the Battle of Solferino. He would be very proud, I think, to see what he originated. And we have 4 Geneva Conventions, each one a different aspect of the battlefield. One had to do with the folks in the field. One had to do with folks at the sea. One had to do with the treatment of prisoners of war. And that actually got a lot of press here in the United States when we were making decisions around what to do with Guantanamo detainees. And if we have time, we can talk about that later. And then the 4th has to do with the treatment of civilians during times of war. The United States is signatory to all of those. There were some additional protocols that were put in place that we are not technically signatories to. They have not yet been approved by Congress, but we've adopted them as if that they are things that we voluntarily take upon ourselves. So relating to the protection of victims of an international armed conflict, otherwise known as an IAC, IAC. Think of an IAC as a country versus a country. So there are very specialized rules when you talk about a country versus a country. There's also something called a NIAC, so the non-international armed conflict. Think of that, a NIAC, as the United States against Al-Qaeda or against ISIS. It is a non-state actor on the other side. And yet what we say is, notwithstanding the fact that it's not 2 countries against each other, there still should be some baseline level of humanity there. And then additional protocol 3 just has to do with those distinctive emblems around the Red Cross and the Red Crescent, et cetera. So let's talk about some of those basic LOAC principles. We spend a whole couple of days in our national security law class that I teach talking about this in very deep detail. And we could do a deep dive into all of these. The ICRC has hundreds and in some cases thousands of pages of commentary relating to this. Considering we have 13 minutes, I don't think we'll be able to go into all of that, but let's hit some high level just to give you a flavor. And so first is something called the Martens Clause. Basically says we need, when no specific rule applies, some general guide for war conduct. And it was named after Theodore Martens. Remember we talked about the Hague Convention. That's the regime under which we have ideas around what sort of weaponry can be used. And basically what he says is something along the lines of, we need principles for the law of nations established among civilized peoples from the laws of humanity and the dictates of public conscience. It's basically a floor, if you will, that we put under all the laws that we have right now, that if there's a law, if there's a situation that doesn't have a law associated with it, let's fall back. It's almost like a golden rule. Let's go back on how we'd want to be treated ourselves. The key LOAC principles that we talk about when we talk about this issue are military necessity, humanity, honor or chivalry, distinction or discrimination, and proportionality. Now, one thing I should be clear is that proportionality also has a jus ad bellum version. Remember we talked about jus ad bellum is how you get into war. So there are also principles that we don't have time for today to talk about when countries should fight wars. Should we attack Russia because they've hit us with a cyber attack? You know, is one bullet across a borderline enough to cause a war? That is the jus ad bellum version of proportionality. what we're talking about here, the rest of the 8 or 9 minutes we have left, is the jus in bello proportionality. So once you're in the war, what sort of engagement are you allowed to have? So let's talk about military necessity. Basically justifies the use of measures needed to defeat an enemy as quickly as possible in a manner that's not otherwise prohibited by other LOAC principles. And so you don't look at just this particular skirmish, you look at really the broader imperatives of winning a war as quickly as possible. And there are whole teams of JAGs, judge advocate lawyers in all the military branches who think through these things anytime there's a particular action that needs to be taken. There's a lawyer behind the scenes, so to speak, and sometimes in front of the scenes, making decisions around whether or not a particular action, either singularly or as a whole, falls within this category of military necessity. There's a famous rule called the Rengelik rule, and Rengelik was named after a general, a German general who was charged. Remember, one of those NMT trials was called the hostages trial, basically in Yugoslavia and other places in Southern Europe, where the Germans would take hostages among civilians. But it had nothing to do with that. It actually had to do with another battle that Rengelik was in, where basically he was charged with, while he was retreating, basically engaging a lot of civilian destruction to keep himself and his men from being killed. And basically it became subject to the rule where you basically are judged as a military commander with what you know at the time. So you're not required to have total omniscience after the fact, Monday morning quarterbacking, but at the time, did you think what you did required a certain level of military necessity? Next is humanity, which sounds kind of odd when you're thinking about the laws of war. What are we talking about, humanity in this context? It really forbids inflicting unnecessary suffering. There's always going to be suffering in warfare. But for example, we limit the use of certain kinds of weaponry. This goes back to sort of the Hague tradition. For example, blinding weapons. You cannot have blinding weapons. You cannot have bullets that are made out of glass, so when they shatter, an X-ray can't see it. Interesting nuances around how we fight wars. You can still blow up people. You can still shoot them. But it's certain interesting elements of how you do that that are prohibited. It talks about fairness in offensive defense, some degree of mutual respect, and also making sure you don't take advantage of the opponent's adherence of law by falsely claiming the law's protections. And what we mean by that is something called perfidy, where you're basically lying or engaging in treacherous activity. The most common approach on that is if you wave the white flag, thinking you're going to surrender, and then they come up to you and you shoot them all. That's a perfect example of that. Now, what it doesn't prohibit, and a good case of this was in the first Gulf War. If you recall, we had our troops and our military coming from different angles. We had some making really what was a fake amphibious landing so that Saddam Hussein would look this way and we came from the famous left hook the other way. That you're allowed to do. You're allowed to use ruses and deception. What you're not allowed to do is to do things like pretend you're injured and then kill the opponent when they try to rescue you. Now, distinction, otherwise known as discrimination, it is meant to oblige parties to distinguish between combatants and civilians. Because we hadn't seen that before. World War II was really the first monstrous example where so many civilians were injured. And so from that, we wanted to say, look, you have to make distinctions between the two, between military objectives and those that are protected property in places. We want to separate those taking part in the hostilities from those who aren't. And sometimes you can have civilians who take what's known as direct participation in hostilities. So you could have a civilian who picks up a gun and starts shooting. That's fine, you can go after them. But if they maintain civilian status, then there has to be some protections around that. And so basically making distinctions even among your own persons and objects. So you can't, for example, be shooting out from one of your hospitals and then claim, hey, you can't shoot us back because, this is a hospital that's protected. There's also the notion of proportionality, especially because it's not prohibited per se to kill civilians. I hate to say it, but there's a proportionality that has to occur. So anytime you hit a military target, there might be civilian casualties. It is the job of the military and their judicial system to basically determine how you use the weapons that you have. For example, should you use a monstrous bomb when you're trying to go after one terrorist target in a densely, in an urban area? No, and that there are actually, very detailed, complicated computer programs that show what they sometimes call a bug splat. They show if you hit this house with this weapon, what does the explosion look like? How many civilians are likely to be killed? And the goal is to obviously keep that number as low as possible in light of the military objective. So for example, if we were to go after, let's say, bin Laden, who was obviously as tier one of a target as ever existed, there would be under this regime a little bit more leeway, for example, to have more civilians killed because the target was so important to the war, as opposed to just some lone, low-level Al-Qaeda chef, let's call it, we wanted to go after. There would be less of the availability to, less maneuverability, I should say, to injure or kill civilians. And so with that, I think I'm just about out of time. And I wish we had more, but I'm happy to stay as long as Laura will let me to take questions.
Thanks so much. We do have a hard end time and I will adhere to it, but let's go ahead and get to some of those questions. I do want to thank everybody for joining us this evening, especially John. Thank you for sharing your knowledge with us. And let's get to some of these questions. So the first question I have for you is, do you think the Nuremberg trials and its body of law has had any real deterrent effect? If so, why are there so many war crimes that have still been and being committed?
Great, fantastic question. I think on balance, it has. And we know that because, Nuremberg, although the Cold War put an end to some of those courts, we've seen subsequent courts that have used the Nuremberg principles in Rwanda, in Yugoslavia, in the International Criminal Court, where we are seeing war criminals in all of those places being brought to justice. Justice is slow. It takes many, many years. They still, in the Yugoslavia trial, and actually when I was in law school, I was working on the War Crimes Commission that fed information into what eventually became the prosecution. One of my friends who's affiliated with us at our center, Adam Weber, actually prosecuted some high-level General Mladic at the Yugoslavia trial. And so I think it's too easy to say the lessons of Nuremberg have been forgotten. I think they were on ice during the Cold War. And then we've seen that, and especially now with the International Criminal Court, where we are seeing, war criminals being brought to justice. Now, can I say that a war criminal will think in the back of their mind, I won't commit this crime, otherwise I'm going to be in jail? Probably not. But at least there is some, at least after the fact, justice that they'll know that they're going to be hunted for the rest of their lives, hopefully.
Are there any laws protecting medical personnel in the field or members of the press?
Yes, so there are protected, so for example, for medical folks, they are protected, they are treated akin to civilians in a way. And so there are some real interesting distinctions to be made, not only in that avenue, but for example, someone whose plane explodes and he parachutes out, you are not allowed to shoot them because they are what's called hors de combat, that they are kind of out of the fight. But if it's an airborne trooper taking a parachute out of a perfectly good plane, then you can shoot them down. So there are really some interesting distinctions to be made among medical folks, press, even what we would think about as combatants, if they are in that category of hors de combat where they are injured or otherwise not in the fight, that there are strong restrictions around your ability to attack them.
I've gotten a couple questions that are on the similar track to this next one, so I'm going to go ahead and we're going to do like a part one, part two.
Great.
So this guest would like to know, how did the parallel war crime trials in Japan compare to Nuremberg in the terms of process and the outcome? Was there any racial bias potentially that had any effect towards the defendants there?
Yeah, the ones in the Far East use many of the Nuremberg principles. It was a lot more of an unwieldy process because they had, I believe it was 11 judges from 11 different countries. Here you basically had some unanimity around what we should do with respect to the trial itself and what we should do with the defendants. There you had 11 judges from 11 different countries with much different views on how to deal with Japanese war criminals. And then you had the complicating factor of what to do with the role of the emperor, right? Because, very much like in Germany, we were sensitive to not upsetting the Germans too much because we needed them to help us in the Cold War.
Mhm.
In a similar vein, a decision was made, let's be careful with what we say about the emperor because we want to make sure while we're occupying Japan that we want Japan intact. So real fascinating dynamics at play in the Far East trial. Maybe we can do a whole nother discussion on that one around how the different countries agreed and disagreed on things, and how the role of the emperor played a role in how they prosecuted folks and what they decided to do. And they created different classes of war criminals, and plenty more to chat about on that.
And while we're on this topic, were there any Italians involved in the trial? Was there any separate trial for Italian crimes? And there was there was a question on, were there any high-level defendants? Did any of the high-level defendants use what we would call like a plea bargain agreement to lessen or eliminate their own crimes?
Well, it's interesting. We talk about plea bargain. I think that there were some who thought that they were engaging a bit of a plea bargain. So there was a guy named Otto Ohlendorf, and Otto Ohlendorf was the lead defendant in the Einsatzgruppen trial. What was interesting is that he willfully served as a witness and testified at the trial. And I think he also, when he had his own trial in the Einsatzgruppen trial, he willfully kind of told everything and spilled his guts. And I think he thought he was engaging in kind of some form of a plea deal, by being so forthcoming, by being so honest about the crimes he and his fellow soldiers committed. I think he thought he was going to get some benefit of the doubt. Similarly, you had the commandant of Auschwitz at the IMT trial speak, and maybe he thought by being open and honest, more so than some of the others, that he thought he was going to get some leniency. Ultimately, Herz, who was in charge of Auschwitz, was killed. He was he was found guilty and killed in Poland, and then Otto Ohlendorf was found guilty in the Einsatzgruppen trial. So there wasn't really what we would call a plea deal. There's some interesting stories that we don't have time today, but in the NMT trials, what wound up happening is that there were various level of appeals that as the US occupation forces, as I said earlier, turned their eyes from the past and the Nazis to the future in dealing with the Soviets, the sentences became reduced less and less and less and less. And so much so that Ben Ferenz, at one point, when there were some leniencies, when some folks were released around Christmas time, he said, Noel, what the hell? He was so incensed that people who really had blood on their hands were taken out of the process because, again, we were so worried about being engaged in the Cold War against the Soviets, and not to mention the fact that we brought on into, basically American soil, rocket scientists to help us with that program, as well as something called the Galen Organization, which took on Nazi intelligence operatives for basically our use against the Soviets. So, because of all that pivoting that happened, in those later trials, you almost didn't need plea deals because those sentences were being reduced practically automatically, unless you're one of the few who had, like Otto Ohlendorf, who had the death penalty.
gotten a couple questions, John, in regards to LOAC and how it applies to the Vietnam War. Specifically, could we talk a little bit about how those standards apply in guerrilla warfare when it's really difficult to distinguish between civilian and combatants?
Yeah, it makes it obviously that much more challenging. And because when you have states against each other, you have folks wearing uniforms, you have folks operating under a certain set of principles. When you're dealing with an insurgency, and that's really what that NIAC is, and non-international armed conflict. So basically, let's give an example. If you were to capture somebody in uniform that was from another country, you treat them in a certain way as a prisoner of war. And there are all sorts of rules and regulations around how you treat an actual prisoner of war. If you capture them and they are not part of an IAC, they're part of a NIAC, I mean, there's a reason why we have, to this day, so many left at Guantanamo, right? At the highest, I think it was 779 individuals in Guantanamo. It's not like all of them were there for war crimes. They were captured because you're allowed to take off the battlefield enemy combatants, or what we call unprivileged enemy combatants, and hold them basically for the life of the conflict. What's different in the current war, or however we call this long war, is that at the end of World War II, even at the end of Vietnam, there is a treaty, there's a signing ceremony, it's done. Here, when is this war against Al-Qaeda over? Is it when we leave Afghanistan, like the president said we're going to do this year? Probably not, because Al-Qaeda has metastasized around the world, has become ISIS, which is metastasized around the world. So theoretically, some have argued that you could keep them in Guantanamo forever until that war ends, which it might never end. At some point, the Supreme Court said really that the hostilities have brought down to such a point that you have to let them go. So it's an ongoing issue. And if you've seen this new movie that just came out, Mauritanian, it talks about some of those issues. And it talks about, actually, they mentioned the Kieran case and things like that, and how you deal in a NIAC situation, or, like you said, in Vietnam or in Afghanistan or however, when you're dealing with a non-state actor on the other side.
Could you talk a little bit about the overview of the development of rape as a war crime?
Yeah, so it's when I was back on that commission dealing with the Yugoslav trials, we actually, and it's crushing and sad that not only we deal with rape, we dealt with mass rape. That was basically, it was ethnic cleansing by rape. And so, from some of those concepts that were done primarily by the Serbs, but also, the other groups against each other, it was used to influence a population, to get them to ethnically, remove themselves from an area, to humiliate them. And that has flown, all of those rules surrounding rape as a war crime are used, it was used by the Yugoslavian war crime trial, the Rwandan one, and in the ICC today, the International Criminal Court as well.
I've had a couple questions kind of on this same tier, which is, are the victors in a war ever subjected to war crime prosecution?
Well, when you think about it, that's that notion I mentioned earlier of complementarity. We are supposed to try our own war criminals, right? So even if we win a war, we can argue if we've won Afghanistan or Iraq, to the extent that we have war criminals among us. And we've seen in the news recently where former President Trump actually pardoned some that were actually prosecuted as war criminals, which has its own set of issues. But yes, we are required under both international law and domestic law to try our own. And the argument is we should try our own. And it's the reason why we're pushing back and why we've never signed the International Criminal Court. And in fact, there's a law in the books that says if they actually were to ever capture, in other words, the ICC were to ever take into custody an American military person, the president has an authorization of military force to go in and get them. It's called the jokingly called the Invade the Hague statute. And so the reason why I think at least morally we're able to push back on that so much is the argument that, look, we, the United States, have a very rigorous system of trying our own war criminals. And so we can argue if we actually do or don't, right, in light of these recent ones that were pardoned, but at least that's the argument.
All right. One of our guests wants to know is, did anyone ever try to use insanity as a defense during the trials?
Well, yeah. So Hess acted insane throughout the whole time, and there was a debate on whether or not he was actually insane or feigning insanity. It ultimately didn't work, and he was hung up. And remember, he was the guy who was in prison for basically the whole length of the war. So even notwithstanding that he was in a British prison because he had flown an airplane to England to try to convince the British to, I don't know, make a deal with the Germans is the thinking. So even the fact that he was crazy enough to do that and acted crazy on the stand, basically most of the time, kind of wobbling back and forth and acting nuts, and sometimes saying he had amnesia, sometimes he was saying he was faking amnesia. And so, yeah, he was a prime example of someone who, if anyone was going to plead that, he would, but it really wasn't something he could plead out. And at the end of the day, he was hung like the other 10.
Do you feel that proportionality was used in dropping the A-bomb on Hiroshima?
It is a great question. And in fact, the International Court of Justice took on that issue, basically on the legality of atomic weapons. And they, at the end of the day, they came up with a very long, convoluted answer that was sort of a non-answer, basically saying, well, if your country's in mortal jeopardy, yes, you might be able to use it. And so then you get into the military justification, right? It is clearly not a weapon of distinction, right? Because you're basically taking out an entire city. So you're not making a distinction between military and civilian. But for some reason, notwithstanding everything that we just talked about today about necessity, distinction, and all those things, at least there is an international court case that basically says that atomic nuclear weapons are not per se prohibited. They might be justified in some circumstances. It doesn't really tell you all the circumstances. And so I think we kind of fall back on, I think if any country were to use it, God forbid, and would have to justify it, you'd almost have to be in a situation of a Samson situation. Basically, this is what we need to do. Otherwise, we're dead ourselves. And anything short of that, I think, is going to become increasingly difficult to justify under the principles we mentioned earlier.
Because while we're on this topic, another guest was wondering about when there's fiber bombings of civilians in Japan and Germany, under the new rules that we have in place today, would those have been legal?
No. And in fact, there were some quoted folks who were involved in those campaigns who said, if we lose this war, we're going to be put up for war crimes. So there was an evolution in thinking around that. So one could argue that at the time, the sensitivity around firebombing civilians wasn't like what it is today. But even at that time, there was an acknowledgement that some of those bombings may have veered off into that area of being a war crime and therefore prohibited and therefore chargeable if we had lost. I mean, let's do the counterfactual, right? Let's do the man in the high tower situation where America, again, God forbid, lost World War II. One could imagine, let's call them the Chicago trials instead of the Nuremberg trials, where you could have Roosevelt, you could have Stimson, you could have Morgenthau, you could have all these folks put up, and they could talk about Hiroshima, Nagasaki, they could talk about Dresden bombing. We could talk about, as I mentioned earlier, Admiral Nimitz acknowledged that, and remember, he was in charge of the Pacific Command. He acknowledged that we engaged in some of that unrestricted submarine warfare, not quite at the level of that Dönitz had made those orders, but to some degree. And so I think it would be really easy, had the God forbid situation, the Nazis won the war, and then we were up for a trial like that, I think they would have had some, no pun, good ammo that they could use against us.
I want to get to some of these resources for our teachers as we start to get really close to our end time.
Yeah.
And I think that you and I can both kind of tag this question together. This guest is wondering if there were any suggestions on how to teach this in high school US history classes today. And I think John and I can both agree to kind of point you in the direction of a great local Illinois resource, which is Courtroom 600, which definitely we can send that out to all of our teachers. I know our museum educator, Melissa Tyer's on the line this evening, and she can get those resources over to you as well. And then John, do you have anything you'd like to put into that too?
I do. I'm going to plug our website again, Crucial, CRSHL, the Consortium for Research and Study for Holocaust and Law. And Laura, I don't know if you can put it on the chat or send it out to everybody.
I'll make sure Melissa sends that out to our teachers for
yeah,
sure.
well, you can send it out to the teachers. What we tried to make it is a one-stop shop for any of the links, any of the resources surrounding Holocaust and the law. The other thing I would recommend is if you wait a year or two, depending on how fast we can move, we're actually creating a book, a treatise on Holocaust and the law that is not only, we think, to be used in classrooms at law schools, but also in high schools too. And in fact, what we're going to do is we're going to include in those books PowerPoints that teachers can use. So basically, it's going to be an off-the-shelf approach to how to teach this. And if any of your teachers have any questions or need some guest lectures through our Crucial network, we have folks who are experts at the war crime stuff, who have experts in art restitution, First Amendment, how the Weimar Republic became Nazi Germany. I give a presentation on that. And again, lessons for today. So any aspect of this, we can either provide you a speaker, we can provide you resources, be happy to chat with you. This, for many of us, is our side hustle, our sort of our passion project. And so we are always available to help you think through some issues. And we've got plenty of great materials on our website.
I've gotten a lot of questions on this one, so this is a blanket answer. A lot of the guests were wondering, can they get copies of your presentation slides? The answer is John is very generous and has already said yes to this.
Absolutely.
So how we're going to get these presentation slides to you, if you could do me a favor, the email that you received today from Zoom that got you into this presentation has my email address in it. I'm going to drop that in the chat as well. Please drop me an email, and tomorrow, probably by the end of workday tomorrow, I will get you a PDF copy of John's slides for you. There was so much information in there. I know there's definitely some things I'd like to go back and learn more about as well. So please reach out to me. Please know that if you're an Illinois State teacher, that PowerPoint is also coming to you in a follow-up email. But if you're not a teacher and you still want them, send me an email. Happy to share it with you. I do have one question, I think, which is a good one for us to end on this evening, and it has a little bit to do with the legacy as in preservation. And one of the guests would like to know, is the trial site still preserved?
100%. Yeah, you can go and visit it. And in fact, it's actually used for real trials to this day. So yes, it is absolutely still preserved. It's still there. And it is on my bucket list to visit. I've got relatives in Munich. So next time I visit my relatives, I plan to visit Courtroom 600. I've seen it enough virtual on the site you mentioned earlier, the Chicago Courtroom 600 folks. It is definitely on my bucket list to visit it in person.
Now, I know we didn't get to every single question this evening. I tried to cover as many as possible, but if you wake up in the middle of the night and you have a question in your head for John, again, feel free to please email me. I am more than happy to pass those on to John, and he will answer them as soon as he is able to.
Or email me directly. Feel free to, I think my info is at the bottom of the slide. Feel free to email me directly, be happy to answer it. And in a strange way, this is what I like to do for fun, because I think it's so crucial, especially in light of what we're seeing in today's society. I did an op-ed in the Chicago Sun-Times with the Illinois Holocaust Museum on this. And this was in November, where we talked about the risks of not remembering the lessons of Nuremberg. And if we don't remember those lessons, how we can fall into the abyss. This was November, a couple months before January 6th. And so might want to dust off that article and feel free to read it. It's on our Crucial site as well.
And then last but certainly not least, before I send everybody out for the evening, I want to remind everybody that at the First Division Museum, we do have a display coming up next week. On the 12th is when it will be open. Don't come this weekend, it's not up yet. On the 12th, we'll be opening up a new display in our lobby for the 75th commemoration of the Nuremberg trials. The 1st Infantry Division played a key role during those trials, since they were the oh my goodness, the word just flew out of my head. They were the guards during the trial. For those of you who have been to our museum before, many of you have probably seen our door from the Nuremberg jail cells. So feel free to please stop on by. Please know that we are reserving ticketed spaces for the museum at this time, and those can be reserved at fdmuseum.org. And you want to head over to the events tab on our website, and that's where you'll see where the tickets are, see if we're sold out that day or not. And feel free to always reach out. I'm always happy to help if you're having difficulties with the website. I want to thank everybody again so much this evening. We're getting lots of comments in. John, thanking you so much. Everybody have a wonderful evening, and we'll see you at our next Date with History in June.
So long, everyone. Thank you
long,
again.
Everybody. Have a great evening.
Thank you, Laura.
Thank you. We'll see you soon. Hope to see you soon.
I hope so. Bye-bye.